Hello there. My name is John Cyboron, and I'm happy that you've selected me to be your mediator. Just like to take this opportunity to introduce you to mediation, what it's designed to do, and typically how mediations work. Just to give you a little information about myself, I've been an attorney for almost 30 years. For over the last 2 decades, I've spent a significant portion of my practice dealing with family law issues: divorce, child custody, child support modifications, post-decree modifications of parenting time, those sorts of things. There's a good chance that you're watching this because you're about to participate in a mediation with me that involves a family law case. Mediation itself is a confidential process that's intended to allow the parties to be creative in making offers and hopefully getting the case resolved on terms that are different than the terms that they would be asking a court for in a contested hearing. So, basic concept today is to see if we can figure out how to resolve your case in an amicable way without the need of using court time and putting your case at the mercy of a judge who will have a fairly limited amount of time to get to know you and the issues in your case before making huge decisions for you and in many cases for your children. So typically how I run mediations is I put each side in its own room virtually, or if you're here in person, your own separate conference room, and I will bounce from room to room, relaying settlement proposals and trying to help the parties and their attorneys come up with settlement concepts, brainstorming, trying to figure out if there's some sort of middle ground where either some issues or perhaps the entire case can be resolved. But in any event, again, the process itself is confidential. I can't be called as a witness. Offers that are made here that don't lead to an agreement cannot be referenced in court. Our rules prohibit that. So feel free to be creative and don't be afraid to make offers. An offer that's not accepted cannot be used against you in any subsequent contested hearing in front of a judge. The process itself is typically 2 hours long. Sometimes it can go longer than that, but usually it lasts at least 2 hours. And I will try to be respectful to both sides. I will give you my honest opinion on certain issues if I have one. Have a specific opinion, whether I think your particular position on an issue might be strong or weak. I think it's important for you to use this opportunity to get an unbiased third party's view of your case to the extent that I might be able to give you some insight into how I think a judge might handle the case if it were put before a judge. I will certainly do that. Keep in mind, of course, that I don't know what a judge is going to do in your case. I'm simply basing any opinion I might offer on my experience as an attorney and having handled hundreds of cases before. I hope you refer back to this if you have any questions prior to the mediation so that you can understand how the process works, and I look forward to helping you resolve your case if at all possible. Thank you.